thank you for joining us. Hope you're keeping safe and well. This is a condensed version of the face-to-face seminar that we did plan to run in March, just as we were going into lockdown. So unfortunately, we had to cancel it. Do appreciate your feedback after this session, not the last one. And we do want to try and do training in this way. So if there is any feedback that you've got to us, then please let us know. If you can keep your microphone muted, this will reduce background noise. We appreciate you're likely to be at home, and having done quite a few of these calls over the last weeks, we understand sometimes that pets and children, etc., make an appearance. Absolutely fine. But if your microphone's muted, that will minimise any disruption. We're going to start with health and safety and then move on to HR as the second part of today's session. In both parts, we will mention coronavirus, and we hope to cover off any key questions you have on this, but there are other subject matters as well that we're going to be discussing. If you have any questions, submit them on the chat function, and then at the end of each part, we'll answer them as best we can, or if we haven't got the answer, we will come back to you directly. Again, if there's anything you want to talk about separately after this, if you want to get in touch, if you've got any specific questions to your business, we will try to answer those as much as we can. So first bit is myself, Emily. I am the health and safety consultant for Health and Safety Support Services Limited. There are a few people on the call that have not been to our seminars before, so we're going to start with covering off the basics of health and safety compliance, then going to move on to some cases that give us some good learning points and look at any changes in legislation that have come about this year, and then of course we will mention COVID-19. So the basics of health and safety compliance. The HSC have tried to simplify bureaucratic laws requiring you to keep paperwork to those that's an absolute necessary. Therefore, the ones that we mention are specified as the important ones. As it says there, you can break down the information that you have or the documents that you should have into information and documents you should hold that is applicable to all employers. Quick wins for you. Make sure that you've got your health and safety at law poster displayed. It's the latest version I have on when I was going around sites, seen quite a few of the older versions out and about. So make sure that you have got the latest version. If you want it, let me know and I can purchase it for you and send it on. Make sure you display your certificate of employer's liability. You need to have what to do in the event of a fire displayed, and you need to have any appropriate safety signage displayed. In terms of documents, this should be your checklist for documentation. We'll go through the health and safety policy in a bit more detail in a second. Your safety plan should cover things like fire evacuation plans, business continuity plans. Your risk assessments and fire risk assessments will depend on your individual business premises and any potential rental agreements you might have, but they are key documents that your insurance company will be interested in, both from a prevention point of view and in the event of an incident. Your accident book should be ideally kept with or very close by to your first aid kit, and you should record near misses in here. These are accidents that didn't happen but can give you significant learning points to make sure that next time an accident doesn't happen. Training should be recorded, and you should monitor it for any refresher requirements. You should also detail the course content to be able to assess their capability. This means putting the actual learning objectives in and the achievements of the course. So if you ever find yourself defending a claim that brings into question your employees' knowledge or their understanding of the training that they've been given. As a business, Health and Safety Support Services can provide template documents for all of these. So if you've not got one of them and you think you need to implement it, again, let me know and I can advise you on how to complete those. In terms of legislation, there's a lot out there and we've tried to break it down. What you'll hear quoted quite often is section 2.1, and that breaks down further into telling you that you must have policies and procedures, you must do that by a competent person, your responsibility extends to third parties and contractors, and just having the documentation in a folder on a shelf gathering dust is not enough. You need to have an adequate safety management culture. There are also employee responsibilities, so they've got to take care of themselves and others. Reasonably practical is terminology that comes up quite a lot. That's the measure of what you're expected to do, taking into account things like cost and time and resources of any actions that you put into place to reduce risk. And competent person is also referred to quite often. That is somebody that within your business or that you can outsource that has necessary training and experience to advise you on all matters of health and safety. Again, if you don't feel that you've got somebody within your business that can do that, please get in touch. So a health and safety policy is the best place to start. This will give you your direction of how you're going to commit to health and safety within your business. It should be broken down into 3 sections. The statement should set out your commitment to managing health and safety effectively and set out what you want to achieve. The responsibility sections will set out who is responsible for specific actions within that policy, whether that be something that the employer is responsible for, directors are responsible for, and even the employees, because as mentioned previously, employees have a duty to maintain their own safety at work and as well for others. The more detail then comes in the arrangement section, so basically the what, where, when. This contains the detail of what you're going to do in practice and sets out your aims to be able to achieve your statement that you put at the beginning. It's likely you will have a lot of supporting documentation that goes along with the health and safety policy, and the health and safety policy is really just your starting point. There's other procedures that you may have, some of them are detailed there, such as lone working, driving for work. A key policy based on the current circumstances with coronavirus is potentially an emergency or a contingency procedure for staff shortages and business closure. How does having less people within your business affect the safety at work? Not having enough people around, does that create lone working? And how secure is your premises when you've got less people there, or potentially if the business is closed completely? A second document to consider, and again, we'll make it more specific to the current circumstances in a second, but is a risk assessment. Risk assessments are not about creating paperwork, but identifying sensible measures. Some risks within your business, depending on what you do, you'll have legal obligations that you've got to meet. In others, it is just a case of best practice and common sense to make sure that everybody is safe. When you're doing risk assessments, you need to think about hazards, so that's anything that could cause harm, and you need to think about risks and the chance of that risk causing harm based on the hazards. Using a risk matrix to give a numerical rating will help you identify whether it's something as a high, medium or low risk. And as per the legislation, you need to communicate your risk assessment to your employees. Again, it's not just a document that you complete, file away, put in a folder. Your employees need to know what the risks are in your business and how they are expected to help with those control measures that you've identified to put in place. We will talk about a specific COVID-19 risk assessment that you should be putting in place to protect your workforce when we come on to the specific COVID section later on. The final part of documentation is training records. Training records should not just be a date and a title of what was completed. There's quite often legal obligations for why employees have to complete training, so you do need to detail what the course involved. As a minimum, employees should receive training on what to do in the event of a fire, which is required by the fire safety reform legislation. They should have basic health and safety awareness so they can understand when you're communicating to them about their risk assessments. And depending on the size of your business or the activities within your business, they may also need first aid, manual handling or COSH as standard. It's also now expected that employers will provide some support on mental health at work within their organisations. And so if you provided them with a training course on how to identify mental health in the workplace, that would meet that requirement. Training might be an option if you've got staff who are furloughed or shielding. In the HR section, we'll talk more about what those words mean. But if you have got staff that are doing that, if you can afford to top their wages up to the 100%, you can get them to do training. So one of the ways you can do that is through an e-learning platform, which we have, and it is maybe a time that if you have got a downturn in work or staff are more available, that you could use this opportunity to make sure that everyone's training is up to date and maybe enhance their skills if there's some extra training that you can give them. But training is a really important way of making sure that everybody is safe at work and they know at least the minimum of how to operate safely within the business. So a case that kind of identifies how something very simple can cause a lot of problems. This is an office-based scenario. A lot of the case law out there is about more serious circumstances, people falling off ladders and from height and things like that. But this just shows that actually even with an office environment, which we naively probably think is very safe, there still can be accidents and it can all still go horribly wrong. There was a worn out carpet in a city centre in an office, and a routine health and safety inspection identified that, and the proprietor was given warning to replace it to avoid it causing an accident. They were checked back later, a few months later, carpet still hadn't been repaired, again given a further warning. 15 months after the initial inspection, the employee at the office suffered an injury. She tripped on the stair carpet when coming down from the first floor because tape had been placed across the carpet rather than the actual carpet being repaired. The employee suffered a broken ankle, a dislocated foot, had 10 days in hospital, ankle surgery, unable to walk for several months and still in pain using a stick almost a year later, and has been unable to return to work since. The accident was not reported until 3 weeks after the incident, and when a visit was made to investigate the accident, there was still no evidence of any improvement made. So if you think of the time scale there, we're looking at about 2 years just to fix a carpet, and it's caused an accident. So the proprietor pleaded guilty. They had a fine and an order to pay legal costs, but it just shows something as simple as a worn out carpet and just putting it off because maybe it doesn't seem as severe as some of the other risks in the building has caused such major problems. So a word of warning, even simple ones, simple cases like that can cause us problems. A positive and how implementing health and safety within your organisation can help. So Cougar Automation Limited, they did a big project on improving their health and safety within their business, and in their words, put it at the heart of their business, and they halved their sickness absence and improved their staff retention. So as you can see on the slide there, they implemented quite a few new processes, all internally with minimal cost. So they made sure they were reporting near misses, which, as I mentioned earlier, are accidents that we were lucky didn't happen, and learned from those. They did a lot of in-house training. They involved their employees, so they had health and safety boards, they had employee reps on meetings, they did poster campaigns, they made all their documents user-friendly and accessible, and had plenty of meetings and briefings where health and safety was commonly discussed. They introduced stress initiatives, awareness programs, and actively monitored the compliance of health and safety and all the things that they were putting in, and audited them both from internal people and external people. The benefits of it, as you can see there, were a reduction in absence, and they also were winning new business. They became award winning for some of the programs that they introduced, and that made them stand apart from their competitors. And the regional director described the benefits as revolutionising their health and safety systems. Their staff had higher morale, lower sickness, and significantly helped in retaining existing customers, and sets them apart when winning new business. Helps the company expand, which then they can reinvest in health and safety measures. So a lot of the questions I get asked is apart from meeting legal requirements, what's the point in me doing health and safety and investing in it and going above and beyond what I legally have to do? And this is why. It's for the benefit of not just your business and being able to make you stand apart from your competitors, but your employees as well. You're looking after their well-being, increasing their productivity if they're higher in morale, and reducing your absence rates. So, this looks very small. I'm not quite sure why. So, anyway, Brexit transition period. This happened a long time ago, and based on what we're going through now, we've probably forgotten all about Brexit. But Brexit did happen. We're still in the transition phase. None of the legislation has changed as yet, and you should still continue to manage risk in your business in a proportionate way. Just wanted to sort of mention it so you didn't think we'd forgotten about it, but right now with Brexit it stands as is. Another change that's happened is welding fumes. So likely to be found in engineering and steel industries. These have been reclassified, and you now need to review all your local exhaust ventilation and respiratory protective equipment to make sure that they now meet the requirements. You need to protect your workers' health because they have got the potential now to cause cancer. So your responsibility as an employer is to make sure that all your PPE and your control methods are reviewed in line with the reclassification of welding fumes. We do have quite a few clients that work in that industry, so we wanted to mention that to make sure they're aware, and I have been personally in contact with those that it does affect, but more just an FYI. Lone working. So the guidance hasn't changed, but it has been updated to give us some more detail. Lone working, probably they didn't realise this when they updated it, but lone working is probably more prevalent now with the amount of people that are home working and are not in our usual business environment. But employers have always had the duty to assess the risks to lone workers and to put controls in where needed. But what's been given us more detail on is that if you carry out a risk assessment, it may be that some duties of a role that are done within a team of people are then no longer safe to do when that person tries to carry them out lone working. So for example, manual handling, moving of boxes, etc., is a task that you might do while there's other people around because they're there to help, but you need to identify those tasks that you cannot do if you are a lone worker. You also need to clarify where the responsibility of the lone worker lies. So for example, if you are a cleaning company and you are sending cleaners out to other locations, they become then lone working, you need to inform the other location of where they're going, of the risks and required control measures that are in place. So that just clarifies the responsibility. And the risk assessment should give more detail on the control methods that are available if for any reason the lone worker comes across a task that they can't do, but it actually stops them from doing their job. They need to have some either method of contacting somebody, an emergency contact details, or how they can actually get help or backup in an emergency situation. Okay, we've avoided it as long as we can, coronavirus. So this is the latest. As we know with coronavirus, everything is subject to change and is changing on a daily basis, but this is what we advise based on the situation as we know it. So I've already mentioned about emergency and contingency plans. This is what they're designed for. So for a situation where something happens out of our control that means our business is affected. It's potentially, in this case, staff shortages or your business's closure or partially closure, to identify what actually steps you're going to take to make sure that you can continue to operate and have a business at the end of it. Bad planning in this instance may mean that some businesses just don't survive from this. The other two documents that are suggested are two different risk assessments. So there's a risk assessment for the well-being of your employees. So it's likely that you've explored the possibility of employees working from home that haven't normally. And mental health is something that, regardless if they're working at home or not, with everything else that's going on, it is potentially going to be affected. So these are the two things that you should consider in one particular area of your risk assessment or as a separate document to establish how you're going to support, identify the hazards that might be, so whether that be external pressures, extra pressures from working from home, and what control methods you're going to put in place to make sure that people are able to continue to work safely, both from a physical point of view, but also from a mental health point of view. The second risk assessment is more about the control of infection and disease. So you may already have one of these depending on your industry and where you work, particularly GP practices. I know they've already got them, but you might want to think about what extra precautions you're putting in place now to cope with coronavirus. So including things like hand washing facilities and PPE. I've got a case example to show you in a second of what a particular client has done. And communication is really important, both from those working at home, those still within your business, just to keep them up to date with what's going on, whether that's you're changing your procedures to make sure that everything's safe and the control of the infections kept to as low risk as you can, or whether you're changing something operationally and they need to know how to do things differently in these circumstances. So like I mentioned earlier, some words we put there: furloughed, shielding. If you don't know what those are, we will be coming on to those later in the HR part of the seminar. Just talked about working from home because that is probably one of the biggest things we've found, particularly with our clients. We now have a lot of people working from home, and there's a tendency, I think if you do work from home, I'm personally guilty of it, that because you're at home you maybe get logged on earlier, you keep checking emails into the evening, you don't take your normal breaks, you sat at the kitchen table, you don't sort of have the same routine to your day. So there's not just a tendency to stick to your working hours, and as managers to check in that everybody's okay with their working hours, but also some flexibility to think about the home situation. That maybe got children, partners that are also working from home, people trying to do homeschooling. So working hours, I think there's a conversation to have with your employees about what their expectation. In terms of communication, try not to be too task focused. There's a tendency for out of sight, out of mind, so that when you do communicate with your staff, you're wanting a catch up on what they've done, how far they've got with something, and unintentionally you tend to micromanage, which can increase the stress levels of employees. So in your communication, try and have the same sort of either banter or chit chat that you might normally have if you were in the office catching up with somebody. In terms of the work setup, DSE is really important. Just because they're at home doesn't mean you don't have that responsibility. Your responsibility extends to them there. So you need to make sure that they have got the right equipment to do the job that you need them to do, that they're set up safely, and they're not curled up on the sofa or on the bed getting back neck strain and not able to do the job properly. So that is your responsibility to check. And again, like I mentioned, just consider the additional complexities that we've got going on at the minute with childcare, homeschooling and all the rest of it. And now's the time to kind of be flexible and support our employees. So in case you wondered what other people were doing in this situation, interesting case. Obviously the client's going to remain anonymous, but we had a client that received an email from the HSE. The HSE had received a concern, they obviously didn't say who it was from, more likely to be a whistleblowing situation, about the measures the company had taken to address coronavirus in the workplace as they were continuing to operate. The client was asked to produce a report based on some very detailed questions that the HSE sent through that needed to be answered, and we had a three-day deadline by which to submit that report. I've put some pictures up of the practical measures which we'll go through that the company had taken, but in addition the company had also got some employees that were working from home, some furloughed and some shielding, so they were taking all the necessary steps in terms of managing their employees. The company is a manufacturing firm and they had orders coming in, so they wanted to continue to operate as normally as possible to ensure the business survives and is there to continue to provide jobs at the end of all this. And these measures that they've kind of put in place, we anticipate we'll keep them in even when sort of lockdown eases up. I think it's important that these kind of preventative measures are kept up for as long as possible to help keep the virus at bay. So things that they've done, they've put extra wall-mounted sanitizers, hand sanitizers up, but they actually managed to get some, and signage around advising everybody, visitors, staff alike, to make sure that they're using them. In terms of the toilets, they put signage on there about maintaining the 2 metre distance, only having one person in at a time. They actually put on the flooring, they taped out the 2 metre, if not more, distance, so it's easily identifiable to the employees in there what 2 metres was and what the safe distance was. So very similar like we've seen in shops, in public spaces where it's marked out. They did that as well for their employees. The setup of this organisation, they haven't got a reception. It is the norm just to kind of walk into the main office when you first arrive and announce yourself as there, whether that be for deliveries or visitors. But obviously they didn't want that happening in this time, so they did ask them not to enter, and they put a contact number on there for them to ring if you arrived, and they would come and meet you at a safe distance outside the premises. So it's just thinking about how you can change your normal procedures to keep in line. And that's just an example of how they amended their workstations. So there's usually about 5 or 6 people working in there. They've got it down to a maximum of 3, and you can see that each of the workstations are over the 2 metre distance apart. In terms of feedback from HSE, obviously the things that they put in place were all straightforward, but it did take time to implement them and communicate it. But the HSE were more than satisfied with the steps they've taken. No further action was required. We don't know where the cause from concern came from. Obviously it's a difficult time for everybody, but the results of the HSE report were briefed to all employees, and all employees were thanked for their cooperation in putting the measures in place. So I think it's just more a word of warning that if HSE get even a disgruntled employee perchance putting an email in saying I'm not happy about what my workplace is doing, they are investigating it, and they are investigating it thoroughly, and they do expect a quick turnaround and a response back. So I think even we need to not be complacent that maybe HSE are pretty busy and they're not going to come and look at little old us. This is not a big company. They are local, and they did want a significant report back, and again, like I said, in a quick time scale. So I've been keeping an eye on the chat function, and there's nothing there yet. So if anyone's got any questions that they think on that, then let me know. You can keep popping them in whilst we move on to the HR bit, but we will then move on to the next section. So you won't be able to see us, but I'm going to move now and keep a safe distance apart from Carol, and Carol's going to come around and do the next bit. So we'll be back with you in just a minute.
Hello everyone. I'm Carol, I'm a HR advisor for the HR Experts. Thank you to Emily for that health and safety update. I hope you found it as useful and informative as I did. I'm going to be talking to you all today about an employment law update, so sharing with you the things that have changed with effect from this April, the new tax year. I'm also going to talk about some recent case law, so some examples of tribunals with other businesses. What can we learn from where they've done things right or wrong? And of course, necessarily, I will be covering some aspects of coronavirus and the implications that that has had on HR. Okay, so launching into employment law changes first off. There are 6 areas that I'm going to cover with you today, just listed for you there. The first being Brexit. And I know that Emily's already briefly touched upon Brexit. And it is much the same message from a HR perspective. So we are now in a transition period, having left the EU. Finally, it actually happened on the 31st of January this year. And in that transition period, employment law remains unchanged, as do the rules for demonstrating the right to work in the UK. So continue to check under the normal rules, UK passports, visas, permits. Nothing changes until we hear otherwise during this transition. But in connection with employment law, there are 2 other aspects to mention that are known to be changing or are significant at this time. The first relates to if you do have any EU citizens employed within your business, they need to apply online for settled or pre-settled status. And they do need to do that as soon as possible. There is a deadline in place that's the 30th of June 2021. And whilst that is currently a year away, that deadline has changed numerous times as the Brexit timeline has changed. So better to do it early on and get the tick in the box and feel reassured that that's been done rather than leave it. The second thing that we know is going to be changing is more for the future, but it's helpful to think about that in advance. So once we do leave the transition period, an Australian points-based system to control immigration will come into effect. And that means that there will be equal criteria for all countries and no preference for European workers. So instead, the points-based system will be based on the skills that individuals have and the contribution that they can make. And that means that there will be a preference for high-skilled workers and those that can fill skill shortages that we have in our economy. So there is talk, for example, of introducing an NHS visa. But what it does mean is it will make it difficult for new low-skilled workers to enter the country. So, for example, any businesses in manufacturing that use a lot of EU workers to support with their manufacturing line, again, it's really important that you identify any EU citizens, get them to apply for settled or pre-settled status, because you may encounter difficulties moving forward, because we know that there's a lack of interest in UK workers in those types of roles. Okay, but that's all we know about Brexit for now. Okay, next change relates to parental bereavement leave and pay. So this change has already come into force. It came into force at the start of April. Following consultation, primary carers, not just parents, will now be entitled to time off work following the death of a child. So this now includes adoptive parents, foster parents, and guardians. And it also includes more informal groups. And by that I mean close relatives or family friends who have taken responsibility for the child's care in the absence of parents. So both parents and carers will be entitled to at least 2 weeks leave following the loss of a child who is under the age of 18 or a stillbirth after 24 weeks of pregnancy. Employees who have 26 weeks continuous service will receive that leave paid at the statutory rate, and 26 weeks service is about 6 months, just to give you an idea. If they have less service than that, they still get the entitlement to the leave, but it is unpaid. So the leave can either be taken in one block, so a full 2 weeks in one go, or it can be split into 2 separate blocks of 1 week. It needs to be taken within a 56-week window from the child's death. You must be flexible with notice requirements for the leave to be taken. There is no rules about an employee needing to give prior notice to take that leave. And equally, parents will not need to provide the employer with a death certificate as evidence. If you are a retainer client of ours, we have already updated your handbook and documentation to include this change. But any ad hoc clients, please speak to us for costings. So in terms of documentation, there's another change here relating to employee contracts, also referred to as statements of particulars or statements of terms and conditions. So moving forwards, employees now have a right to receive their contract on their first day. Previously, you had a full 8 weeks in which to issue that to them. Now it needs to be given to them on day one, even that if that is at the end of their working day, it's still got to be on day one. And there is now a more specific list about what you have to include within that contract. And I've listed those there for you. I won't read them out loud, but you can see that there's quite a lot of detail now that has to be included in contracts. So it can be made up of more than one document. You can have a principal statement and a further written statement, but across those two forms of documentation, you do need to ensure that every area on that bullet point list is being fulfilled. You do not need to make any retrospective changes. So for any employees already in receipt of an employment contract, you don't need to change that and reissue it to them unless they ask you to. It's just for any new joiners from now on. Finally, there are two other aspects that you do need to make sure that you cover off in writing in some form, but it doesn't have to be in the contract. So that means it could be a separate policy, it could be in a handbook or an appendice to the contract. And those things are, you need to cover sick pay and procedures, and you also need to detail about disciplinary and grievance procedures. Disciplinary and grievance you can put into one document, or you can have a separate document for each. It's just something that needs to be written down and available for employees to access. Okay, next up, IR35. So as you may have seen, this has been delayed for a year due to coronavirus. It is quite a dense and difficult topic to get your head around. So it's nice to see that HMRC have been understanding of that, and with everything that's going on at the moment with coronavirus, they've delayed it for 12 months so that people have a bit of breathing space and time to get their heads around it. So I won't go into this in too much detail, as it's not something that's happening right away. But just to give you the heads up, new rules are for larger businesses, so those that satisfy at least two of the criteria listed on the screen there. And they focus around the need for a business to take responsibility for determining the employment status of their off-payroll workers. And then the business is responsible for applying the correct tax regulations. And that might include meaning that moving forward, you have to deduct tax and NI from invoices and also pay employer contributions on top. So it could lead to an additional cost for you if it relates to the types of workers that you engage. At the moment, an individual is responsible for determining their own employment status, so people can just be engaged and say, look, I'm self-employed, and deal with their own tax. It's shifting the onus so that businesses have to take responsibility of that as well, and HMRC will be looking to ensure that you do it correctly. It is just large businesses at the moment, like I said, but as we've seen from other changes like pensions auto-enrolment, changes tend to start with large businesses and then get rolled down for SMEs. So don't think that you're going to be exempt forever, although this change isn't happening for you now, and definitely at least not for 12 months. Okay, so I'm going to talk to you about holiday pay now. We've seen another change come into effect, and this is the April 2020 change, so we're back on live changes that are taking place now. So during periods of annual leave, workers are entitled to receive their average rate of pay, and that can be different to their basic rate of pay. So sometimes people earn bonus and commission, and that means that the amount that they take home each month is different. This can also apply where you give people an additional amount for working at the night, on a weekend, as part of their contracted hours. So it's mainly those groups that this affects. Now, workers have already been entitled to receive their average rate of pay for periods of annual leave. The change relates to the reference period that we look at when determining an average rate of pay. It was 12 weeks, it's now 52 weeks, so a full year needs to be looked at. The reason for that is to take account of, for example, seasonal workers or industries where there's, for example, winter pressures, that kind of thing. If somebody hasn't been employed for a full 52 weeks, then you just look at the full employment period that they've got. So however long they've been employed for, if it's 9 months, you just look at all 9 months until you get to the 52 weeks. The pictures on the slide are from a recent government campaign. So these have been put up on billboards, they're on TV adverts. It shows the focus that the government is placing on ensuring compliance in this area, and it also demonstrates that workers are going to be very much aware of their entitlement here and their right to have it. So make sure that you are applying this rule properly, because it's very much in the public eye at the moment. Okay, national minimum wage. This is something that is reviewed and pretty much always goes up year on year. And the new rates that were effective from the start of April 2020 are displayed for you there. For the majority of the workforce, the 25 and over rate will be the relevant one. So that's £8.72 per hour minimum. And that is quite a big jump from the previous rate, and it's only going to keep increasing. So the Conservative government has pledged that the minimum wage will rise to £10.50 for anybody who is 21 or older by 2024. So expect continued increases. And be aware that what this could mean is that the gap between those in entry-level positions and those in mid-level positions in your organisation, the gap could close, because whilst you are obliged to continue increasing to ensure that national minimum wage is met, it may not be practical or possible for you to increase everybody else's wage in response. So a bit of scope for discussion or thought there about what that means for your business. As well as national minimum wage, statutory payments in other areas also increase, and I've just listed those for you on the screen so that you're aware of them. In terms of statutory sick pay, just to highlight as well, that is now payable from day one of sickness absence for anybody with coronavirus symptoms or who's self-isolating. Normally it's payable from day 4, and if anybody is off during this pandemic but for non-coronavirus related reasons, the usual rules do apply. I've also listed family friendly and redundancy rates there just for your information, and if you need to utilise those moving forwards, please ensure that you are using the updated rates. Okay, so that's all of the changes that have come about in April 2020. So now I'm going to move on to tell you about some recent case law. I've got 2 different cases to share with you. So the first case relates to shared parental leave. So shared parental leave is where a woman's maternity leave is divided between both parents. So one parent takes part of it and the other also takes part of it. They share that allowance. A case was brought to tribunal by a chief constable who thought that sex discrimination was taking place. He was paid at the statutory rate when he took shared leave, but his female colleagues were receiving enhanced maternity pay. So they were getting more than he was for the same type of leave, and he felt that that was sex discrimination. In the Court of Appeal, they found that it was not discriminatory to pay a man on shared parental leave less than the enhanced rate of maternity pay paid to women on maternity leave. And that's actually quite a surprising outcome. I think the HR team here at the HR Experts were surprised with that, and you might be as well. So to dive into that a little bit more, I've got for you about why the court came to that decision. And it's interesting as well that they refused a further appeal because this means that the verdict is final and it remains binding. So if you do offer enhanced maternity pay within your organisation, you are not obliged to pay an enhanced rate for shared parental leave. So the court's verdict was based on there being an exception to a comparison between employees. They said the predominant purpose of such leave is not childcare, but other matters exclusive to the birth mother, resulting from pregnancy and childbirth, and not shared by the husband or partner. So by that, they mean that maternity leave is specifically related to a woman going through, I suppose, the trauma of childbirth. An interesting distinction, and the topic, it may be reopened, because let's consider this distinction does not apply in cases of adoptive mothers or those who use surrogates, for example. So I don't know that this is necessarily a closed book, but for now, the verdict is final and it is binding, like I said. So a second case to share with you is all about GDPR. It has been a hot topic, but then we got Brexit, now we've got coronavirus, but let's not forget about its importance. So I want to share this with you because the ICO has now issued its first fine for a breach. So we can look at what's taken place and try and learn from where others have gone wrong. Specifically, a pharmacy who were fined a full £275,000 for going wrong in relation to GDPR. And actually that fine was initially meant to be £400,000, but it did get brought down. It seems like the ICO found some sympathies. So where did they go wrong? Well, three key areas really. 500,000 documents were left outside, unsecure and exposed to the elements. So the documents included names, addresses, dates of birth, NHS numbers, really sensitive data, and they were just left outside. They were damaged by rain, entirely unsecure, available to any passerby. They also went wrong in failing to cooperate with the ICO. There was a lengthy period of poor communication and cooperation in which the pharmacy failed to respond initially. They then failed to respond adequately by providing insufficient and unsatisfactory information in response to the commissioner. So their responses did not demonstrate that they understood the severity of their errors. It's one thing to make an error, but then to not heed the warning is another. They neglected their obligations to GDPR, but then they also neglected the need to correct the problem. And the third area where they went wrong relates to inadequate policies, privacy notices, that kind of thing. So most of their policies were still labelled draft. They'd not been rolled out. They were in template forms, and therefore they weren't adequate. The pharmacy wasn't utilising privacy notices. They didn't have a data protection officer, and staff had not been trained in and therefore did not understand GDPR and what they had to do. So they clearly went wrong in a number of ways, in a very severe way. They went about as wrong as you can go. But we can still learn from this. We can still draw out the areas that are important and what we need to do in relation to GDPR. So here's a quick checklist of questions to consider in relation to your organisation and what you're doing for GDPR. So, do you have a GDPR policy in place which has been rolled out and is both known and accessible to all staff? Have you issued privacy notices to all your staff and covered all necessary areas within the notice? Have you made it specific to your environment and not left it as a template? Is sensitive data on your premises stored in a way that protects it from damage? Be sure to think about cyber damage here as well as physical damage. Have you appointed a data protection officer? And have you trained your staff on GDPR, including their obligations and responsibilities? So that's just 5 quick points to consider. We do have GDPR templates available to clients, and we also have an e-learning website that has a GDPR specific module as well, if you would like any help within this area. Okay, so with those 2 cases, we now move on to coronavirus. So it has had some impacts on HR, notably in the introduction of the coronavirus job retention scheme and the ability to now place staff on furlough. So furlough is defined as a period of leave. That's what that word means. I think it was new to all of us in March, but that's what the dictionary says. So what is it and who is eligible? So the scheme was put in place for businesses that can't operate as normal due to lockdown, and it's the government's way of supporting the economy and assuring that businesses can keep going and people will still have jobs as far as possible once normality resumes. The scheme is not available to the public sector, unfortunately, nor is it available to any businesses that are in receipt of continued public funding. But the scheme can be used by all private sector UK employers operating PAYE on or before the 19th of March 2020. It does not apply to employees who were hired after the 19th of March. Any employees who have been absent from the business and or whose employment has been terminated since the 19th of March are in scope, but they must be rehired by the employer before the scheme can be utilised. Once placed on furlough, an employee cannot undertake any work at all for the employer. Be really careful with that, because you don't want to undermine any claim that you make by getting someone to do a quick job. It's no work at all to be on the scheme. A minimum period of 3 weeks is necessary for every occasion of furlough, and the scheme is currently available until the end of June 2020. So the scheme provides you with a grant that will cover 80% of an employee's regular wage, capped at £2,500 gross per month, plus the associated employer national insurance contributions and minimum auto-enrolment pension contributions on that subsidised wage. So you do still need to make sure that you are contributing to pension, even if you've got someone who's furloughed. Employers can choose to top up an employee's salary to a full 100% if they so wish. In all cases, signed agreement from an employee is needed to place them on furlough. We have a template letter that we can provide to you when needed if you are utilising the scheme. Please just let us know if you need that. So I've said that 80% of pay is covered. Well, what does that mean? It's really straightforward for salaried staff who receive a set monthly payment, and the government has an online calculator to help for these individuals. But where individuals are in receipt of variable pay, you will need to take an average of their earnings to determine what they are due. But please note, commission and bonuses cannot be counted in the calculation. So for employees whose pay varies, the employer can claim for the hire of either the same month's earnings from the previous year or average monthly earnings in the previous tax year. It's also interesting to note that it is lawful. You can pay under the national minimum wage for furloughed workers if by paying them 80% it takes them below that threshold. That is allowed. New words have come out in relation to coronavirus. Specifically, there's been a lot of talk about people being vulnerable or needing to shield. So people who are vulnerable are those that fall into a group defined by the government, for example, over 70s. Vulnerable people may still be able to work, for example, from home, or they may not be, depending on if that's something that they can do, or depending on the individual circumstances of why they're vulnerable and what kind of job role they fulfill. So linking with health and safety, it would be good to risk assess individually for these staff. Shielding is different though. Shielding is for people who are at a very high risk of severe illness from coronavirus. Employees who fall within the category of shielding will have received a letter from their GP or other NHS healthcare provider instructing them to remain at home entirely. So staff who are shielding and have received this type of letter, they can be placed on the furlough scheme in accordance with the normal eligibility criteria. Or if they can't, or maybe anyway, you might want a shielding employee to work from home. Emily's already talked a little about this, so I won't go into too much detail, but a key thing to note about working from home, if that is the arrangement that you come to with an individual, they do need to be paid at their normal rate. It is something that we're all doing in light of the current pandemic, and a more open approach to home working is being taken by many. From a HR perspective, ACAS guidance encourages employers to consider which roles and tasks can be done from home, and they state that this might involve doing things differently to the norm or differently to what's ideal, and not assuming that a role cannot be based at home. It's also advised by ACAS that you consider individual employee needs. For anyone, for example, anyone with childcare responsibilities or a long-term health condition or a disability, working from home is not a one-size-fits-all. Okay, coming on to SSP then. As I've already said, it's now payable from day one of an occasion of sickness absence for COVID-19 related cases. So that means it's payable during periods of self-isolation, both where the employee themselves is symptomatic and where it is a member of the household who is symptomatic. You can pay SSP to a shielding employee if they're not eligible to be furloughed, but please note that an employee cannot receive both SSP and a payment under the furlough scheme. It is one or the other. And then finally, just in relation to annual leave entitlements continue to accrue for anybody who is on furlough. So exactly in the same way that it does for staff on maternity leave, annual leave entitlements are not affected by placing somebody on furlough. It is not yet absolute in the guidance from HMRC and the government website whether annual leave can or cannot be taken whilst on furlough. So proceed with caution here. Our advice would be that you make sure that somebody has seen out a minimum of 3 weeks on furlough prior to taking any annual leave where possible. Similarly, there is no official word yet on whether you can compel employees to use their holiday allowance during the lockdown. I know there are some worries that for as long as lockdown goes on, people are continuing to accrue that entitlement so that when they come back to work, they're still going to have a full year's allowance, but less time to take it in. And that's going to create continued issues of staff shortage. However, you're not obliged to allow people to cancel any pre-booked leave. So there is at least that, but please ensure you're consistent. So if you don't allow one person to cancel their leave, don't allow another. Just make sure you're being fair. Okay, so that's the key things on coronavirus. I hope I covered your key questions in that area. And that brings to a close all of the HR related information I'm going to go through for this session. So I'm just quickly going to hand back to Emily for one final slide before we move on to questions.
Thank you, Carol. I hope all the information we've given you has made sense and you've understood what we've said. But like I said, if you've got any questions at all, please submit them and we will try our best to help. Just wanted to give a bit of an overview of the support we offer. This is obviously just a snapshot providing these seminars. From a health and safety point of view, from that business, we offer retainer packages of which you can build up the package to include, like we mentioned, the competent person, have somebody identified as that person, writing your policies and procedures and doing your risk assessments. Like the client did that had the HSE investigation, we can do project work for you and do those accident investigations or HSE investigations or even apply for accreditations. Similarly for the HR experts, we have retainer packages that mean you can have an advisor at the end of the phone to answer those questions for you, all the template documents that we've talked about, all the updates that we've mentioned that happened in April, we will make sure that they're all in your documentation for you. We do on-site support, but that can happen now. We can do it remotely. We've done a lot of meetings for clients on their behalf, doing things on Zoom and holding meetings, and so our on-site support continues even though we physically can't be there. All our packages are bespoke, so if you do want to know anything about the services we offer, either if you're not a client and you're interested, or if you're already a client and you want to explore if there's anything else we can do for you, please get in touch. We also have an e-learning platform that has CPD accredited courses on it, not just for health and safety, but for any other courses as well. So we can do mixtures of all those packages and build up whatever you need. So I'm just going to have a look at the chat function, and we're all good. If there's anything anyone wants to put in, then just let me know. If anyone just wants to put any feedback, anything at all, just something to let us know that you're still listening, really, because we can't see you. So if anyone wants to write anything, just pop something in very quickly before we end it. Still listening. Fab, Michelle. Yay.
If you do have any more slightly personal questions related to your business that you don't want to discuss in a public format, our contact details are on the slides. If you want to follow up afterwards, we'll happily help you outside of this webinar, so just let us know. But other than that, thank you for listening.
So Michelle, is there a deadline for the signed furlough letters that should be sent to staff? So I'm assuming that's if you're sending them for staff that are already furloughed. It's as soon as, really. There's no time scale on it.
Yeah, we've got to be mindful that this guidance really only came out at the end of last week. So as soon as you can in response to that deadline. For any staff that you may furlough from this date onwards, get it prior to them going on furlough. Obviously that might not be possible if you'd already made that decision before this guidance came out. Do what you can.
And just to note as well, the letters that come back signed, you do need to keep for 5 years. That's the retention period for those. So when you do get signed letters back, they need to be kept somewhere safe. They need to be kept for 5 years.
You should have a record regardless of the furlough having taken place. Think about payroll audits, that kind of thing. It's important that we can make sense of what's happened with pay history for these types of reasons.
So I hope that answers your question, Michelle. Obviously, if you've got more questions on that, just give me a buzz. You know, you've got my details. Other feedback, thank you, Alistair, very informative, brilliant, thank you. Cara, thank you for your feedback. Lisa, thank you. Fab, so you're still there and listening, brilliant. Okay, everybody, so we will end it there. We are going to, we've recorded it, so we will put a link out, so if you guys want to refer back to it, then it's there for you, and then anyone that's listening on the recorded message, please get in touch if you've got any questions, and we'll do our best to answer them. So thank you very much for today. Stay safe, everybody, and we'll hopefully speak to you soon.
Thank you for your time, everyone. Bye for now.